Do ERISA disability carriers and plans use a comorbid medical guideline if you're filing a claim for multiple medical conditions? The general answer is yes. Most disability carriers or plans will look at each individual medical condition and then look at the totality of the medical condition and associated restrictions and limitations in determining whether or not they're going to accept a claim or deny a claim or terminate benefits. So let me give you an example. Let's say you're a 55-year-old marketing director. Your disability claim is based on an allegation that you have fibromyalgia, mild cognitive impairment, and you have gastroenterological issues. And what the disability carrier is going to be doing is reviewing the medical records. And they may see that you also have, for example, a herniated disc and you're a diabetic. How is this all going to play out in the analysis? Well, the disability carrier is going to review your medical records, the applicable policy provisions, and the applicable law in the circuit in which you live. Your medical records are going to be reviewed by a medical consultant that the disability carrier has in-house or out-house. I call them peer review doctors. And what they're trying to determine is whether or not your medical records document a medical impairment that's disabling, as that term is defined by the terms of the policy of the plan. They may ask for additional information from your physician in the form of a supplemental attending physician statement to address the medical impairment and obtain any other medical records that they think are appropriate. Now, the claims adjuster is going to be consulting with that medical peer review provider. And if they determine there are any psychiatric issues, they're going to ship that part of the file out to their behavioral specialist for an opinion. Once all these reports come back, the adjuster is then going to be determining whether or not the medical condition rises to a medically determinable impairment, and whether that impairment is such that you, again, are disabled as the term is defined in the policy. So they're using this kind of sorting hat analysis. If they don't think the impairment, if they don't think there's an impairment, or they don't think the impairment is disabling, then they're going to toss that medical condition out the window as a basis for your disability claim. If they think that it's a medically determinable impairment, they're going to kind of put that one aside. And then they're going to work their way through each one of these medical conditions. Then they're going to look at these comorbid medical conditions, the diabetes, the herniated disc, and determine whether or not either of these rise to the level of an impairment, whether or not they are disabling, and what the interaction is between the claimed medical conditions and these comorbid conditions. How do they interact? Do they all rise to the level of impairment? And as part of that, they're also going to be looking at the limited pay provisions for mental nervous conditions or subjective medical conditions. These two limitations generally will allow for the payment of benefits for just 2 years. So they're going to go through this sorting hat analysis, throw out the ones they don't think are medically determinable impairments, stack up the ones that they think are medically determinable, and say, well, is there a subjective medical condition limitation I can apply that'll limit benefits to 2 years? Or is there a psychiatric mental nervous limitation that will just limit benefits to just 2 years? So they're trying to determine what's medically determinable as an impairment. Is it disabling? And can we limit benefits to just 2 years because of one of the policy limitations? And in doing that, they will decide whether or not they're going to deny the claim, whether or not they are going to terminate a claim that is being paid on the basis that you've hit your applicable 2-year mental nervous limitations or subjective medical condition limitations. I don't want you to let this sorting hat process result in a claims denial. If you've gotten a denial or termination where the carrier hasn't felt that your medical conditions rise to the level of an impairment or are disabling, or consider the comorbid conditions and their relationship to each other, give me a call at 727-894-3188 for a complimentary consultation. I can help you get the disability benefits you deserve, regardless of where you live in the United States and regardless of the nature of your medical condition. 727-894-3188.